Hello again everyone, Prosecutor Fabrica here. For this video, we are going to discuss the importance of knowing who are your relatives by consanguinity and affinity. Who are your relatives by consanguinity? When you say relationships of consanguinity, two people are related to each other by consanguinity if one is a descendant or an ascendant of the other, like for example, a father and his daughter or a mother and her son, a parent and a child. They are what? Ascendants and descendants of each other and vice versa. Or if they share a common ancestor like brothers and sisters, they are still relatives by consanguinity because even if they are not ascendants and descendants of each other, still they share a common ancestor. That is, they belong to the same parent. Now, when you talk about relatives by consanguinity, you cannot do away without discussing some provisions in the new civil code relating to consanguinity. Here they are. Let's start first with Article 963 of the new Civil Code. It states, and I quote, proximity of relationship is determined by the number of generations. Each generation forms a degree. So, in that same example, a mother and her son, the mother belongs to one generation. Her son belongs to another generation. Each generation forms a degree. On the other hand, in Article 964 of the new Civil Code, it states, and I quote, a series of degrees forms a line, which may be either direct or collateral. A direct line is that constituted by the series of degrees among ascendants and descendants. So for example, X has a son named Y, Y has a daughter named Z. So they belong to a series of degrees in the direct line among ascendants and descendants. Now, a collateral line is that constituted by the series of degrees among persons who are not ascendants and descendants but who come from a common ancestor. So, let us say X and Y are siblings. X has a son named A, Y has a son named B. A has a daughter named C, and B has a son named D. Between X and Y, A and B, C and D, they are what? Collateral blood relatives. They constitute a series of degrees among persons who are not ascendants and descendants because in that example, A and B are first cousins, whereas C and D are second cousins. So they belong, although they do not belong to a direct line constituted by a series of degrees among ascendants and descendants, but they belong to the collateral line because they constitute a series of degrees among persons who may not be ascendants and descendants of each other, but they come from a common ancestor. Now, for a clearer picture of what I'm talking about, let's take a look at this table on degrees of consanguinity. In the direct line, ascent is made to the common ancestor. Thus, the child is 1 degree removed from the parent, 2 degrees removed from the grandfather, and 3 degrees removed from the great-grandparent. Let us say this is you. You are what? 1 degree removed from your parent. You go up. And then you are already 2 degrees removed from your grandparent, 3 from your great-grandparent, and 4 from your great-great-grandparent. These are what? Your relatives by consanguinity in the direct ascending line because you go up. Now, you also have relatives by consanguinity in the direct descending line. So, where do we find them? Again, this is you. When you say descending line, you go down such that your child is 1 degree separated from you. your grandchild is 2 degrees separated from you, and your great-grandchild is 3 degrees separated from you, and so on and so forth. It's very easy. What about in the collateral line? In the collateral line, ascent is made to the common ancestor, and then descent is made to the person with whom the computation is to be made. Thus, a person is 2 degrees removed from his brother, 3 from his uncle, who is the brother of his father, 4 from his first cousin, and so on and so forth. So, let us say you're asked, how many degrees are you separated from your first cousin, whom you fondly describe as your first degree cousin? In this table, it's already given, no, that you are 4 degrees separated from your first cousin. But for purposes of knowing how to arrive at the exact degree, this is how to do it. Again, this is you. The rule is you must make first an asset to the common ancestor. Who is the common ancestor between you and your first cousin? Di ba, ang grandparent mo. So, you must go up first. So, this is you, 1, 2 degrees. After reaching the common ancestor, you then make a descent to the person with whom the computation is to be made. The person with whom the computation is to be made is your first cousin. So, again, 1, 2, and then you go down, 3, 4. Diba? Your first cousin is the son or daughter of your aunt or uncle. So, that is the reason why you are 4 degrees separated from your first cousin. Now, knowing this, do not anymore call your first cousin as your first degree cousin. It's wrong. Because in law, your first cousin is actually your fourth degree relative by consanguinity. And then the same goes for all the other relatives here. You just have to follow the rule stated in Article 966 of the new Civil Code. Okay? What about adopted children? Adoption has the following effects. Number 1, it severs all legal ties between the biological parents and the adoptee, except when the biological parent is the spouse of the adopter. Number 2, it deems the adoptee as a legitimate child of the adopter. Number 3, it gives the adopter and the adoptee reciprocal rights and obligations arising from the relationship of parent and child. And number 4, adoption gives the adopter and the adoptee the right to be legal and compulsory heirs of each other. This is based on Section 16, 17, and 18 of Republic Act 8552 or the Domestic Adoption Act of 1998. So, in a sense, the adoptee is in the same category as the legitimate child of the adopter. So, they should be, in effect, treated also as relatives by consanguinity of the adopter, but not the blood relatives of the adoptee. Let's now go to relatives by affinity. The question is, who are your relatives by affinity? In the case of Tigangay versus Wakas, the Supreme Court described affinity as follows. Affinity denotes the relation that one spouse has to the blood relatives of the other spouse. It is a relationship by marriage or a familial relation resulting from marriage. Relationship by affinity refers to a relation by virtue of a legal bond such as marriage. Relatives by affinity, therefore, are those commonly referred to as in-laws, like your mother-in-law, father-in-law, parents-in-law, children-in-law, son-in-law, daughter-in-law, brothers-in-law, sisters-in-law, cousins-in-law, or they could also refer to your stepfather, stepmother, stepchild, stepbrother, stepsister, and the like. So long as, in the case of your stepfather, so long as your stepfather is married to your mother, so long as your stepmother is married to your father, So long as, let's say, your stepmother has a child or has a daughter by a previous marriage, she becomes your stepsister. And you are what? Already related by affinity with respect to your stepsister or with respect to your stepmother or stepfather. Because, as I said, relationship by affinity is a creation of marriage. It refers to a relation by virtue of a legal bond, such as marriage. Without the marriage, there is no affinity to speak of in the first place. Affinity may also be defined as the relation which one spouse, because of marriage, has to blood relatives of the other. The connection existing in consequence of marriage between each of the married persons and the kindred of the other. Take note of this. The doctrine of affinity grows out of the canonical maxim that marriage makes husband and wife one. The husband has the same relation by affinity to his wife's blood relatives as she has by consanguinity and vice versa. This is, again, part of the decision in the Tigangay case. So please take note of it. In the same Tigangay case, there is, however, no affinity between the blood relatives of one spouse and the blood relatives of the other. For example, a husband is related by affinity to his wife's brother, correct, but not to the wife of his wife's brother. In the same vein, there is no affinity between the husband's brother and the wife's sister. In resolution number 002396 of the Civil Service Commission dated October 18, 2000, the Commission made the following pronouncement. Affinity has been defined as the relationship of a husband to the blood relatives of his wife, or of a wife to the blood relatives of her husband. It is thus clear that a spouse is related by affinity only to the blood relatives of his or her spouse. Okay? So, this is an application or in application to the rule in the Tigangay case. Although this resolution number 00236 was decided earlier, and of course this is not controlling because this was only decided by the Civil Service Commission. But later on in 2013, this was affirmed, so to speak, because the definition given by the Civil Service Commission of affinity is the same as the definition of affinity in the Tigangay case, which was decided in 2013. Now, since the husband, according to this resolution, shares no degree of relationship with his wife because they are treated as one, then the sister or brother of the wife is also 2 degrees removed from the husband. So, for purposes of determining who are your relatives by affinity, take note or please bear in mind that the wife and the husband, the spouses, are treated, considered, or regarded as one, such that in this example, or as stated in this resolution, the sister or brother of the wife is also 2 degrees removed from the husband. I'm showing to you this consanguinity and affinity chart. And this consanguinity and affinity chart is based on what was decided in the case of Tigangay, wherein in that case, the Supreme Court made mention that you and your spouse should be treated, regarded, or considered as one for purposes of determining who are your relatives by affinity. So as you can see in this chart, in the bottom portion, it shows who are your relatives by affinity. But at the same time, they are also the relatives by consanguinity of your spouse. So the same goes for the upper portion. The upper portion shows your relatives by consanguinity, but at the same time, they are also the relatives by affinity of your spouse. Okay? So have a closer look. Your first degree relative by affinity is your parent-in-law or your son or daughter-in-law. Your second degree relative by affinity is your grandparent-in-law, grandchild-in-law, brother or sister-in-law. Your third degree relative by affinity is your great-grandparent-in-law, great-grandchild-in-law, uncle or aunt-in-law, nephew or niece-in-law, and so on and so forth. The same goes for the upper portion. So if you are the spouse, then these are your relatives by affinity. Now, what is the importance of knowing consanguinity and affinity in criminal law? It is important because of the following provisions in the revised penal code. Number one, the justifying circumstance of defense of one's relative under Article 11, paragraph 2. It states, and I quote, anyone who acts in defense of the person or rights of his spouse, ascendants, descendants, or legitimate, natural, or adopted brothers or sisters, or his relatives by affinity in the same degrees, and those by consanguinity within the fourth civil degree, provided that the first and second requisites prescribed in the next preceding circumstance are present, and the further requisite, in case the revocation was given by the person attacked, that the one making the defense had no part therein. Number two, the mitigating circumstance of immediate vindication of grave offense committed against one's relatives under Article 13, paragraph 5. It states, and I quote, that the act was committed in the immediate vindication of a grave offense to the one committing the felony, his spouse, ascendants, descendants, legitimate, natural, or adopted brothers or sisters, or relatives by affinity within the same degrees. So again, in the justifying circumstance of defense of one's relatives, it makes mention of relatives by affinity and relatives by consanguinity. In this mitigating circumstance of vindication, immediate vindication of a grave offense, it likewise makes mention of relatives by affinity within the same degrees. In the absolutory cause of relationship in favor of accessories under Article 20, remember? Accessories who are exempt from criminal liability. It states, and I quote, the penalties prescribed for accessories shall not be imposed upon those who are such with respect to their spouses, ascendants, descendants, legitimate, natural, and adopted brothers and sisters, or relatives by affinity within the same degrees, with the single exception of accessories falling within the provisions of paragraph 1 of the next preceding article. Again, it makes mention of relatives by affinity within the same degrees. So, under Article 20, if you still remember, if you are an accessory with respect to a principal who is your relative by affinity within the same degrees as your ascendants, descendants, or brothers and sisters, you are exempt from criminal liability. So for purposes of Article 11, paragraph 2, Article 13, paragraph 5, Article 20 of the Revised Penal Code, applying what we have learned in the previous slides, the relatives by affinity in the same degrees mentioned in those articles are your parents-in-law, sons or daughters-in-law, and brothers or sisters-in-law. On the other hand, the relatives by consanguinity within the fourth civil degree are your uncles or aunts, nephews and nieces, granduncles or grandaunts, grandnephews and grandnieces, and your first cousins. We also have Article 332 of the Revised Penal Code. This article makes mention of persons exempt from criminal liability, also an absolutory cause, just like in Article 20. It states, and I quote, "No criminal but only civil liability shall result from the commission of the crime of theft, swindling or estafa, or malicious mischief committed or caused mutually by the following persons." So there is an enumeration here. 1, 2, 3, and then the last sentence. My focus is only on the first or in paragraph 1 of Article 332 because it makes mention of relatives by affinity in the same line, such that if the one who commits the crime of theft, the one who commits swindling, or the one who commits the crime of malicious mischief against you is your relative by affinity in the same line, that relative is also exempt from criminal liability, just like your spouse, ascendants, and descendants. Now, I am showing Article 332 for purposes of emphasizing the importance of knowing who are your relatives by affinity. Otherwise, you will not be able to be accurate enough to determine who are these relatives by affinity in the same line. Okay? Now, knowing who are your relatives by consanguinity or affinity is also important when it comes to appointments in the civil service. Thus, the prohibitory norm against nepotism in the public service is set out in Section 59, Book 5 of the Revised Administrative Code of 1987 on nepotism. It states, and I quote, "All appointments in the national, provincial, city, and municipal governments or in any branch or instrumentality thereof, including government-owned or controlled corporations, made in favor of a relative of the appointing or recommending authority or of the chief of the bureau or office or of the persons exercising immediate supervision over him are hereby prohibited." As used in this section, Section 59, the word relative and members of the family referred to are those related within the third degree of consanguinity or of affinity. Again, when the appointing authority or recommending authority appoints a relative within the third degree either of consanguinity or of affinity, that appointment is prohibited and will be regarded as nepotism under Section 59 of the Administrative Code of 1987. There is, of course, an exemption to what I've stated a while ago, because if the appointing authority or recommending authority appoints persons employed in a confidential capacity, or if the appointee or if the position is that of a teacher or that of a physician or member of the armed forces of the Philippines in the civil service, meaning to say in the government, even if the appointing authority or recommending authority appoints a relative within the third degree of consanguinity or of affinity, he will not be liable for nepotism under these exemptions, provided, however, that in each particular instance, full report of such appointment shall be made to the Civil Service Commission. The restriction mentioned in subsection 1 shall not be applicable to the case of a member of any family who, after his or her appointment to any position in an office or bureau, contracts marriage with someone in the same office or bureau, in which event the employment or retention therein of both husband and wife may be allowed. Lastly, Section 79 of the Local Government Code of 1991 provides that no person shall be appointed in the career service of the local government if he is related within the fourth civil degree of consanguinity or affinity to the appointing or recommending authority. This is similar to Section 59 because for the same reasons, a recommending authority or an appointing authority cannot or is prohibited to appoint relatives by consanguinity or of affinity within the fourth civil degree. This is even an extension up to the fourth civil degree, compared to Section 59, wherein it is only up to the third civil degree of consanguinity or of affinity. So on that note, I end my discussion for this particular topic. And before turning off your gadgets, please like, share, and subscribe. Thank you.